Every year, thousands of families discover the same brutal truth, not at the reading of a will, but weeks later when the bank says no, the court says wait, and the attorney hands over a bill that nobody saw coming. Your father spent 40 years building something, a paid-off house, some savings, a car, a life, and in his final act of responsibility, he hired an attorney, signed a document, and believed, genuinely believed, that he had taken care of his family. He hadn't. He had just enrolled his grieving children into one of the most expensive, most time-consuming, and most quietly predatory legal systems in the United States. And the document that triggered all of it, his last will and testament. Today we're going to talk about what a will actually does, not what the commercials say it does, not what the attorney implied it would do, what it actually, mechanically, legally does the moment you die. And we're going to look at the alternative, the instrument that wealthy families have been using for over a century to bypass this system entirely. The instrument that most middle-class Americans have never been offered, not because it doesn't exist, but because it doesn't generate nearly as much revenue for the legal industry. This is not legal advice. This is pattern recognition. Consult a licensed estate planning attorney before you take any action. But understand what you're walking into first. Let's start with a real situation. A retired electrician in suburban Sacramento dies in late 2024. He leaves behind a paid-off 3-bedroom home worth approximately $540,000, a checking account with $38,000, a Toyota Camry, and a will, properly drafted, notarized, witnessed, and locked in a fireproof safe, naming his daughter as the sole beneficiary. By every legal standard, it was a valid document. His daughter believed she had inherited around $578,000. 18 months later, after court hearings, attorney billings, creditor notices published in local newspapers, appraisal fees, executor accounting filings, and a disputed claim from someone who alleged her father owed him money decades ago, she received $426,000, the gap $152. Zero Zoo went to the court system, the attorneys, the appraisers, the bond, the publication fees, and the creditor settlement. $152,000 from a middle-class estate because of one document choice. Here is what most people do not understand about a will. A will is not a transfer mechanism. It is not a key that unlocks your assets and hands them to your family. It is an instruction letter addressed to a probate court judge. That's it. When you sign a will, you are not bypassing the legal system. You are scheduling your family's mandatory appearance in it. The moment you die with assets titled solely in your name, 3 things happen automatically, and none of them benefit your family. First, every account in your name is frozen. The checking account, the savings account, the brokerage account. Your daughter cannot walk into that bank with your death certificate and access a single dollar. The bank manager, the one who has known your family for 30 years, will say the same thing every time. I'm sorry. We need letters testamentary from the probate court before we can release anything. Second, your real estate enters a legal condition called abeyance. It belongs to no one, not your children, not your spouse if the title was in your name alone. Until a probate judge issues a formal order, the property is in limbo. Third, a legally protected window opens for any creditor, any old business partner, any ex-spouse, any stranger with a half-plausible claim to file against your estate. In most states, that window stays open for 4 months after a formal notice is published in a newspaper. In 2026, your private financial death notice is still being printed in the legal classified section of local papers, where creditor firms with automated monitoring systems can find it within hours and begin building their claims. That is the legal structure your will activates. Now your daughter needs an attorney. She cannot navigate the inventory requirements, the appraisal filings, the creditor notices, and the court accounting procedures alone. So she calls the attorney whose name appeared on her father's paperwork. And here is where it gets expensive in a way that almost nobody explains publicly. In several states, the attorney's fee for handling a probate case is not negotiated. It is not market rate. It is set by statute. A legally mandated percentage of the gross estate, not the net, not what's left after debts, the full appraised value. In California, the statutory fee schedule works like this: 4% of the first $100,000, 3% of the next $100,000, 2% of the remaining balance up to $1 million. On a $500,000 estate, that produces an attorney's fee of $13,000. The executor, your daughter, is entitled by that same statute to the identical fee, another $13,000. That's $26. Zero before a single court filing fee is paid, before the probate referee's appraisal charge, before the bond premium. before the notice publication cost, before any extraordinary fees. The attorney petitions for when something goes sideways, and something always goes sideways. On a clean, uncontested $500,000 California estate in 2026, the realistic total extraction runs between $32,000 and $45,000. If there's one contested creditor claim or one disputed appraisal, that number can cross $60,000. Florida uses a slightly different structure, a presumed reasonable fee rather than a hard statutory schedule, but the presumption is still percentage-based, and Miami-Dade County is currently running 14 to 19 months from filing to discharge. Ohio is generally cheaper, but Cuyahoga County's backlog runs around 11 months even for uncontested cases. Los Angeles County, as of recent filings, is sitting at 16 to 22 months for a clean case. 3 different states, 3 different fee structures. The same outcome, months of waiting, tens of thousands of dollars extracted, and a family sitting on a frozen estate they cannot touch. Here's what that waiting period actually costs beyond the legal fees. During those 14 to 22 months, the property doesn't sit for free. Property taxes continue. Homeowners insurance continues. Utilities need to stay on to prevent damage. If there's a lawn, it has to be maintained or the city issues fines. If there's a mortgage, those payments don't pause for probate. The executor can pull from estate liquid assets for routine expenses, but non-routine expenses require court approval, and getting court approval in a backlogged probate system takes weeks to months, so maintenance gets deferred. A roof leak doesn't get fixed on schedule. A burst pipe sits longer than it should. The asset depreciates while the system processes. The fees are the visible cost. The asset deterioration during the holding period is the invisible one. Now let's talk about what the wealthy have been doing for 100 years to avoid all of this. It's called a Revocable Living Trust, and it is not a tax shelter, not an offshore structure, not an aggressive legal maneuver. It is the most established, most IRS recognized, most universally accepted estate planning instrument in American law. It has existed for over a century. Every state recognizes it, every court acknowledges it, and it completely bypasses the probate system. Here is how it works in plain language. While you are alive and mentally competent, you sign a document creating a trust, a separate legal entity that can hold property. You name yourself as the trustee, meaning you retain full control of everything during your lifetime. You name yourself as the primary beneficiary, meaning all the income and assets remain yours. And you name a successor trustee, typically an adult child or spouse, who takes over when you die or become incapacitated. Then, and this is the step that most people either skip or do incorrectly, you retitle your assets into the name of the trust. Your house title changes from your name alone to your name as trustee of your Revocable Living Trust. Your bank accounts get retitled the same way. Your brokerage accounts the same way. Investment properties the same way. This process is called funding the trust, and it is where the entire strategy either succeeds or collapses. A trust that is not funded provides no probate protection. If your house is still titled in your individual name when you die, it still goes to probate, regardless of what your trust document says. Signing the trust is half the work. Funding it is the other half. You cannot skip it. When a properly funded trust is in place and you pass away, the process looks completely different. Your daughter brings your death certificate and a copy of the trust document to the bank. The bank sees that the account is titled in the trust's name and that she is the named successor trustee. She gets access, typically within days. No court order, no letters testamentary, no statutory fees, no 18-month wait. For the real estate, she presents the death certificate and a successor trustee affidavit to the title company. The property becomes legally hers to manage or sell according to the trust's terms. No probate filing, no public record, no creditor exposure window. Let's run the comparison directly. Robert dies in 2026 with a paid-off $500,000 home and $100,000 in a checking account. Total estate, $600,000. If Robert had a will, the California probate math produces roughly $15,000 in statutory attorney fees, $15,000 in executor fees, and approximately $5, zero in court costs, appraisal, bond, and publication fees. Total extraction, approximately $35,000. Time to distribution, 14 to 20 months. Public record, yes. Creditor exposure, yes. If Robert had spent $3,200 in 2024 on a properly drafted and properly funded revocable living trust, his daughter would have accessed the bank account within a week, listed the house within 3 weeks. The only costs would have been roughly $800 in administrative and recording fees. Time to distribution, Around 4 months, and only that long because she chose to wait for a better real estate market. Public record, no. Creditor exposure, drastically reduced. The difference, $34,000 in fees and 14 months of your family's life. Here is what you actually need to do. Step 1. Inventory every titled asset you own. Pull out the deed to your house, your bank statements, your brokerage statements. Look at the exact name on each one. That name determines whether the asset goes through probate. Step 2. Find an estate planning attorney, not a generalist, not someone who drafted your divorce paperwork, an attorney whose practice is at minimum 60% sedates planning. Ask 2 direct questions. Do you draft revocable living trusts? And do you handle the funding of the trust as part of your fee? If either answer is evasive, keep looking. Step 3. Get a flat fee quote. A complete trust package in 2026, including the trust document itself, a pour-over will to catch anything not transferred into the trust, a durable power of attorney, a healthcare directive, and the deed transfers for your real estate. Should run between $2,500 and $4, $500 in most U.S. metro areas. If someone quotes you $8,000 for a straightforward middle-class estate, get a second opinion. Step 4. Fund the trust. After signing, actually retitle your assets. Your attorney should handle the deed transfer. You will need to walk into your bank with a copy of the trust and retitle your accounts. Call your brokerage and do the same. Update beneficiary designations on retirement accounts. Those generally stay outside the trust but need their own updated forms. Do not skip this step. Step 5. Review every 3 years. Your assets change, your accounts change, your family situation changes. Sit down with your spreadsheet every 3 years and confirm everything is still correctly titled. The 2026 probate landscape is not getting easier. Court budgets in most major states have been cut in 3 consecutive funding cycles. Backlogs in metro counties are at historic highs. Legal fees have been quietly rising under the cover of reasonableness standards. And creditor monitoring firms now use automated systems to scan newly filed probate petitions across every county in the country, filing claims within hours of the creditor notice publication. The system has never been more efficient at extracting wealth from middle-class estates. And it has never been easier to bypass for families who know what instrument to use. The wealthy figured this out generations ago. The Revocable Living Trust is not a secret. It is not exotic. It is not aggressive. It is a 100-year-old legal instrument sitting in plain sight, available to anyone, at a cost that is less than a single month of probate attorney fees. Your family built something over a lifetime. The decision you make now about how that transfers determines whether your children receive it, or whether a court system does. Get the trust drafted, get it funded, get it reviewed. That is the entire strategy. If this analysis was useful, share it with one specific person, not a broadcast, one person, someone you know who recently mentioned updating their will and believes that means their estate planning is finished. One conversation now can prevent a very expensive discovery later.